Thanks, Andrew. Are we ready to get started?
You have one more. You got one more minute, Judith.
Okay, thank you.
Right now.
Judith, I think we could start.
Okay. Good evening, everyone. My name is Judith Yaney, Yeany. I'm a senior regulatory officer with the New Jersey Department of Environmental Protection. That's essentially an in-house attorney. I have with me David Appy from our commissioner's office, who is, you can please give your title, David, because I don't remember it.
I am a senior advisor in the Office of Legal and Regulatory Affairs to the Commissioner.
Thank you, David. We're here to conduct a hearing on a request by the Township of Mount Olive for a partial release of a conservation restriction held by the DEP. I'm going to give the background on that in a minute. But before I go any further, I just want to notify the participants who might not have heard the announcement that we are recording this proceeding tonight, and we will make a video and/or transcript of the hearing available online as soon as we're able to post that online. So the format that we're going to follow tonight is that I'm going to give an introduction as far as why we're having this hearing. I'm then going to ask the Township of Mount Olive and its representatives as the requester to explain more about the request, after which we'll take public comment. When we get to that portion of the proceeding, I'll lay some ground rules for the public comment. And I will give information at the end about how to submit additional comments on this matter for 2 weeks following the hearing. So what I will do first is, again, explain why we're meeting tonight to have this hearing and a little bit about the township's request, after which they'll give some more detail. So we're here today to discuss a conservation restriction that the DEP holds on a property that is located in Mount Olive. The street address is 3100 Continental Drive. The current tax lot designation is Block 301, Lot 4 in the Township of Mount Olive, Morris County. The entire tax lot is about 58 acres, but the portion that's covered by this restriction is approximately 2.8 acres, and the area for which the township has requested the release consists of approximately 0.89 acres, and we'll go into more detail about what that involves. So in accordance with the New Jersey Conservation Restriction and Historic Preservation Restriction Act, which is codified at NJSA 13:8B-1 et sec, DEP has received a request from the township for a partial release and modification of a deed restriction held by the department on this property. The department has determined that the proposed modification of the deed restriction constitutes a partial release of a conservation restriction under this act, and therefore under the specific Section 5 of the act, which is codified at NJSA 13:8B-5, the department, as the holder of the restriction, is required to conduct a public hearing on the proposed partial release before making a final decision on the township's request. And under Section 6 of the Act, codified at NJSA 13:8B-6, the approval of the Commissioner of Environmental Protection is also required for the proposed partial release. So in this situation, the DEP is both the holder of the restriction, but also the DEP Commissioner has general oversight over releases of conservation restrictions, regardless of whether they're held by DEP or not. So the Commissioner has a bit of a dual role here. So the background of the restriction and why the township has filed this request is that the department imposed this restriction as part of a December 26, 1990 deed by which the DEP conveyed the property to the New Jersey Foreign Trade Zone Venture, which was acting as an intermediary in the acquisition of the property by the BASF Corporation. In 2012, the township acquired the property from the BASF Corporation, subject to the restrictions in the original deed from the department to the Foreign Trade Zone Venture. The township has now requested that the department agree to modify one of the restrictions in the 1990 deed from the department to the Foreign Trade Zone Venture, which established a no-access zone along a portion of the frontage of the property. The conditions of the no-access zone allowed underground utilities to be placed within the no-access zone, but specifically prohibited the construction of an access road to the property within the restricted area. The record on why the department imposed the no-access zone is a little sketchy at this point, but our belief is that the no-access zone was intended to be primarily a scenic buffer restriction, which we interpret to qualify as a conservation restriction under the Act. The township has now requested to modify the restriction to allow the installation of an access road within a 0.45 acre portion of the no-access zone and the installation of stormwater infrastructure and above ground utilities in a 0.44 acre portion of the restricted area to serve a planned 100% affordable, non-age restricted 180 unit rental housing development that's intended to satisfy more than half of the township's round 4 affordable housing obligation. The proposed development will be undertaken under the township's 3100 Continental Drive redevelopment plan, which was recently adopted by the township by ordinance. The township representatives will show a map in a minute that shows the proposed area of disturbance and where the no access zone is located on the property. In very basic terms, the construction of the the construction of the access road outside the no access zone does not appear to be feasible due to freshwater wetlands constraints and other factors. The remainder of the 1990 deed restrictions will remain on the property and are not the subject of this hearing. The area proposed to be released from the no access zone restriction consists of approximately 0.89 acre total, and again, will be shown on a map that we'll share with you in a minute. So with that, if the township representatives want to give a little more detail about the location of the no access zone and what the scope of this release request, I will turn things over to you.
Thank you, Ms. Yanni. My name is Jonathan Testa, Law Office of Dorsey and Samro. We are the municipal attorneys for the Township of Mount Olive and the applicant in this matter. And you are correct. The township is looking for a partial release of approximately 0.89 acres of the no access zone. Doing our due diligence, it was difficult to determine the purpose of the no access zone when it was initially created in 1990. Nonetheless, the goal here is to proceed with an abundance of caution to allow the public to have an opportunity to be heard on this issue and to proceed in accordance with the required statute, which is the New Jersey Conservation Restriction and Historic Preservation Restriction Act. The township does, as you correctly identified, have a concern as to the constraints on the property, the environmental constraints regarding the freshwater wetlands, and more specifically, the riparian buffer area that essentially leads to the primary access roadway, which would be Continental Drive, which is a public roadway. We do have the deed restriction of record, which we indicated would be submitted as Exhibit 1, and that does list several restrictions, including the no access zone. You are correct in making the statement that it does permit underground utilities so long as the property is restored to its prior condition. In its current form, that deed restriction would preclude the ability to provide an access roadway there. And that is why we are seeking this release at this point in time. The alternative would be to seek an approval from the DEP through permitting to allow for a disturbance of the riparian buffer area, which we do not want to do. We are again proceeding to understand the environmental sensitivity of the wetlands area, and we believe that this is the least restrictive way to do so, and will have the least impact on the environment. And you're correct in stating that the purpose of or the need for this access zone to be partially lifted is for the purpose to provide access to a future affordable housing development, which would be 100% affordable development of up to 180 rental units, all very low and moderate income. It'll provide housing for at least 50% for veterans, as well as at least 12 units would be for supportive housing for those in need. In addition, you are correct. It's, if approved, ultimately would satisfy not only a majority or more than half of the township's affordable housing obligation for the fourth round. There's also a component which would allow for bonus crediting on a 1-for-1 amount up to 25% of our obligation. The goal here is to limit the environmental impact through a 100% affordable housing development, as opposed to allowing, we call it incentive zoning through inclusionary zoning across the township in various other areas. With respect to the no access zone, with respect to the other restrictions on the property, the township has agreed and has no issue with maintaining what's called a 50-foot buffer area, which does run along Continental Drive, the entire width of the property.
Mr. Testa, sorry to interrupt.
Yes.
Is there someone on your end of the call, since we're operating in a hybrid format and some of the attendees are not in person? Is there a way to put the map, to share the map via Zoom? So
Yes, I was going to do that in a moment just to give more detail. We can do that now.
Thank you.
I believe that was listed as Exhibit 6.
I should mention while we're pulling that up that any of the exhibits Mr. Testa references that have not already been posted by the department online as part of the public hearing notice for this hearing, we will make sure that we post online and make them accessible by tomorrow at the latest.
Thank you. So Exhibit 6, I believe, is a 2-page exhibit, or maybe 3 because there is an alternative. So first page of Exhibit 6 depicts the constraints on the property, including not only the wetlands area, the immediate adjacent restrictions for the buffer area around the wetlands, and then the riparian area that surrounds that too. So what you'll see in Exhibit 6 on the first page of that essentially shows that the area that the township proposes to develop the site on, which is approximately 22 acres or so, which Mr. Tederico is currently providing the mouse over with the arrow. That will be the area that's proposed for this development. This has been, by the way, I forgot to mention, was part of a negotiated settlement with Fair Share Housing Center and another objector to the township's affordable housing plan, Housing Element Fair Share Plan, to meet its 317-unit fourth round affordable housing expected need obligation. Fair Share Housing Center does endorse this project. They're aware of these issues that we're trying to hopefully overcome at this point in time. This area of the property is most suitable for this development. We do need some space, obviously, to allow for the development to be there. Shaded in a dark pink area running adjacent to Continental Drive along the southwesterly side of Continental Drive is both the 50-foot buffer, which is really a shade of red, and overlaid over that is the darker pink the darker pink no access zone area, which is again approximately, it's 2 point. 2.781 acres in size, the no access zone. And if you go now, Mr. Tederinko, if you go to the second page of the exhibit, this shows the proposed encroachments into the no access zone area, mainly the drive, which is located directionally wise on the eastern side of no access zone, approximately midway through the property itself. This would not be disturbing the riparian buffer area, but obviously would have to go through the current location of the no access zone. And it's approximately 4.4 or I'm sorry, 0.55 acres, 0.55 acres in size. In addition, we have some stormwater basins that are surface level basins in compliance with NJDEP stormwater regulations that would have to be placed there. There will be some subsurface utilities, which the no access zone already permits. The surrounding areas, aside from the surface stormwater basins, as well as the portion or segment of the access roadway, are essentially the only areas that would not be able to be restored to the prior condition. The surrounding areas, the areas surrounding the stormwater basins and the roadway would be restored with native tree species to existing grade at that point in time, so long as it's compliant with the NJDEP stormwater restrictions. You'll notice that the riparian buffer area also runs somewhat adjacent to the no access zone, and it also runs into the 50-foot buffer area. And that is the reason why we're pretty much landlocked. We're locked in because of the riparian buffer area. And if you can just scroll down a little bit on the screen of the exhibit, you can see the southerly side of the property where the wetlands pretty much emanates from. It entirely encompasses the southerly side of the property, for the most part, going into the northwesterly direction of the property. So the proposal would be to, again, lift that the partial release of the no access zone to allow for that roadway. Obviously, that would not be able to be restored because otherwise you can't get access to the property itself. The stormwater basins cannot be restored to its previous condition, but all the areas surrounding it would be able to be restored, again, with native plant species. To note, although the municipality is a Highlands municipality, it's both in the Highlands Preservation Area and in the planning area. The township is only has conformance status for the preservation area. It did not exercise its option, which was its right back in 2004, to opt into the planning. This property is not in the preservation area. It is in the quote unquote the planning area. Interestingly enough, it's also part of the New Jersey Aspire zone. I don't know when that originated from, but it is a property listed in the New Jersey Aspire for economic development and redevelopment for business or residential use. In addition to that, I did want to speak briefly about some of the background and history that you had touched upon before, so there is no misconception about the status of this property. The environmental deed restrictions components are, again, just the 50-foot buffer area and that 2.781 acres of the no access zone, in addition to obviously the wetlands areas that I've previously described. The area encompassing where this proposed 100% affordable development would be is not restricted by an environmental, as far as we know, and we've seen in record at all, any environmental constrictions. It would be permitted to be developed otherwise for research and development and office space. We believe that this type of use is less of an environmental impact than what a research and development office space development would be. And it serves not only a constitutional purpose under the Fair Housing Act and Mount Laurel Doctrine, but the public policies of the state of New Jersey provide much needed affordable housing for the protected class of very low and moderate income households. As I said before, the township is in the preservation area. Approximately 80% of the township's land area is in the preservation area. So it is restricted significantly by the Highlands Act. However, this property is not, it's only in the planning area. And there are provisions in the Highlands Act and the regulations that allow for waivers for 100% affordable housing developments, nonetheless. With respect to the history, as I just indicated, the DEP did execute a release of a repurchase clause that was in a 1990 deed. That release was initially authorized by the former commissioner of the NJDEP in 2004. Specifically, it was released by former Commissioner Bradley Campbell. And in March of 2012, prior to the township purchasing the property, former Commissioner Bob Martin of the NJDEP executed an actual formal release, which that, along with the correspondence from former Commissioner Campbell, were then recorded in the Morris County Clerk's office, and they can be found a public record at book 22134, page 0647. Township did purchase the property, as Ms. Janey stated before, from BASF Corporation on September 4th, 2012. That deed is also recorded in the Morris County Clerk's deed book at 22134, page 651. Andrew, if you don't mind, can you scroll down to exhibit, same exhibit, but the third page of that? And this would be the alternative for an access to the site, which, as you can see, and then, by the way, that's depicted with a dark shade with a green line, center line in between it, which the township would seek to have the DEP, through permitting process, allow for that permission to encroach into the riparian area. So again, we're trying to proceed in the most environmentally reasonable manner to try to not disturb these wetlands areas, meanwhile allowing us to develop the property for this regional need of affordable housing.
Okay, thank you, Mr. Testa. Is there anything else the township would like to add to the record before we open things up for public comment?
Yeah, I just wanted to clarify, Ms. Yaney, that the page 2 of Exhibit 6, that is what is proposed. I don't want the public to be confused or the recording to misunderstand that. And that's why we're here today, is to seek this partial release.
Yeah, and if I could just clarify two things before we open things up for public comment. I think I said at the beginning that it's a total of 0.89 acre with 0.44 being for the access road and 0.45 being for the above ground stormwater and other infrastructure. I think at some point during your testimony, you might have said 0.55, so I just want to make clear it's 0.44. The other thing is that I appreciate the township mapping out what the alternative was, and I just want to make the public aware that even though there is a 50-foot buffer strip that runs along the entire frontage of the property, the terms of that buffer did allow access roads. So we had a buffer that allowed access roads, and we had a further no access zone that didn't allow access roads. Now, it's a little hard to reconstruct this at this point, but I think the intention of the DEP at the time was to push the access road further down for a project that was supposed to be combined on the adjacent lot that had been owned by BASF. So I think something that may have made sense to the department at the time and may not have fully taken into account things like wetlands, made sense at the time, but is probably not going to work for the project that the township, as the current owner of the property, now is seeking to construct. So just a little additional factual information there.
And Ms. Jenny, you are correct. It is point four. I apologize for.
Not a problem. I just want to make sure we're all on the same page.
But the exhibit does indicate incorrectly on it, the roadway as being 0.55. We will correct that prior to submitting that to you, okay?
That's great. And once you send it to us, we will post it online for members of the public who might want to see it after the hearing. Okay, before I lay the ground rules for public comment, I see we have a few attendees online, but can you just tell me how many members of the public we have attending in person?
There is one person attending in person here.
Okay. So maybe I don't have to get so restrictive about public comment. Normally, we would limit the time for each commenter if we didn't think we could accommodate everybody.
Absolutely.
So why don't we take the comment from the member of the public who's in person first, and then determine if anybody who's attending remotely wants to comment. And
The member of the public has indicated they don't wish to provide a public comment at this point in time.
okay. I can see that at least one of our remote attendees might be a public official and one might be a DEP employee. So I don't know if the third person wishes to comment. I guess if you're attending remotely and you would like to comment, perhaps use the raise hand function on your Zoom and we'll figure out how to let you comment.
Just to let the record reflect, there is no one raising their hand at this point in time.
Thank you. Okay. I generally try to leave the record open on a hearing for half an hour in case people are delayed in traffic, and I think we're almost at that point. So I will put on the record how people can submit comments after the hearing. So we will accept written comments from the public on this request for 2 weeks following this hearing, which would take us to the close of business on June 4th. And the way to submit comments is to send them to the general inbox for my office, which is otpla@dep.nj.gov, G-O-V. Andrew, is there a way for me to drop that? I don't see a chat function, but I see a Q&A. Could I type that into the Q&A if someone sees this recording later?
You could try to do that. If not, it is in the public notice
And
already.
anybody who sees this recording will have found it on our page where the information is about how to submit comments.
That is correct, including with the subject
circular.
heading instructions as well.
So if I can type it in, I will. But yeah, all this information is on our website.
And it's also on the township's website as well, in the legal notices section, miscellaneous tab.
Okay. I don't think I can put it there. Normally, if we do this by Teams, I can put it in the chat. But
Let's try to, maybe we can just pause for a moment. We'll try to do that function with the Q&A.
well, again, I think if we post this on our notice page, anybody who found the recording is going to see the hearing information. So I think the most important point is you have 2 weeks to submit written comments. And certainly if anyone is confused about where to send them, you could contact Andrew, the township administrator, and he'll guide you through that process.
Correct.
Okay. So is there anything else that anyone would like our commissioner to consider as part of this request and would like to put on the record here as part of the hearing?
I believe so.
Okay. So we will leave the comment period open for 2 weeks, after which DEP staff will review the record and will make a recommendation to now Commissioner Potasnak about whether to approve the township's request. And if that request is approved, the form that it would take is for DEP to execute some sort of release document with the township that's backed up with the certificate that's required under the Conservation Restriction Act, where the commissioner would explain the basis for his decision.
So that will be recorded as well in the Morris County Clerk's office, correct?
Absolutely, and that would be a public record at that point.
Thank you.
Okay, unless anybody has any questions, I think we will close the record of the hearing, and I'll note the time being 6:29 p.m. And I appreciate everyone's time joining us here to give us your input on this request.
Thank you.